Welcome to today's program titled BIPA and GIPA, Litigation and Compliance Updates. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or legal opinion on any specific facts or circumstances. The content is intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ada Dolph. Ada, please go ahead.
Thank you. Hello, everyone. Thank you for joining us for this update on BIPA and the growing litigation surrounding GIPA, which we'll get into later. I am Ada Dolph. I'm a partner in the Chicago Seyfarth office. I handle BIPA class action litigation. I've been involved in some efforts to amend BIPA at the legislative level, and now we're delving into, I'm handling GIPA cases. And with that, I'll turn it over to my co-presenter.
Thank you. Welcome, everyone. My name is Danielle Kays. I'm an attorney out of our Chicago office as well. And I handle class action, biometric, and employment law litigation. I've had the pleasure of litigating tons of these BIPA class actions and arbitrations over the years, involving many different types of technology and counseling clients on them as well. And I too am excited as we delve into the area of GIPA. With that, we can go to the next slide. So welcome to everyone. Some of you may have been here for, this is today our third installment this year of biometric and BIPA updates. So many of you may have been on these webinars over the past 2 times this year, and whether you were or not, you know there's been a lot going on in the world of BIPA. You probably all have heard of the White Castle decision and are familiar with it. If you are not familiar with it, spoiler alert, it's not on its face, it's not very great. The defense bar, we fought the good fight this year, but earlier in January 2023, the Illinois Supreme Court held that an individual's BIPA claims accrue upon every single scan or use. So for example, in the White Castle case, it dealt with employer time clocks, which have been really the crux of most BIPA litigation class actions in Illinois, though there are many more different types of technology that are being targeted as well. But in this case and in many others that are similar to it, the court held that every time an employee punches in or out, scanning their finger, their hand, face, whatever it may be, they accrue a claim. And that is the same as if they've been using the same time clock for 10 years, for 5 years, for 1 year. They accrue a new claim every single time they use that device. Of course, in other contexts, it can mean that every log into any program or device using a biometric identifier also accrues a claim each time. We're not going to get too much into this case. I'm assuming that many people are pretty familiar with it, and you know, we want to talk about what this all means ultimately. But just to rehash a little bit, because I know not everyone else, you know, looks at this daily. In February 2023, the Illinois Supreme Court issued this decision and based its majority decision on statutory interpretation, at least their interpretation of it, as well as legislative intent. They noted in their interpretation that while they were, interpreting the statute to give this claim accrual theory, um, the support, that they said it would entangle businesses in astronomical damages that would constitute annihilative liability that was not contemplated by the legislature and possibly be unconstitutional. Regardless of that, they held that where statutory language is clear, it must be given effect, even though the consequences may be harsh, unjust, absurd, or unwise. And if you've been following along with us, this was the second of a number of Illinois Supreme Court decisions just this year. But over the past few years, there's been some decisions that affected BIPA greatly. And this was the second, maybe even the third time that the majority of justices explicitly called on the Illinois legislature to review these concerns and act because of the effect it was going to have on businesses. Now, of course, this decision did not go well with, businesses in Illinois. Many organizations, were unhappy with this response. And because the decision was written by a very narrow majority, and many of the judges who issued the decision were not even elected or on the bench when oral argument in the case was held, as well as a number of other factors, of course, White Castle filed a petition for rehearing. Many organizations filed strong amicus briefs in support of a rehearing petition, and those were accepted. However, ultimately, in late July, the Illinois Supreme Court again denied, or I shouldn't say again, but they denied the petition for rehearing and upheld their decision. Now, interestingly, they did, oh, I'm sorry, excuse me, can you, next slide, please? Okay. Ultimately, the majority did not issue a new opinion. However, the dissent did. And of course, dissents are always the most fun. You can go to the next slide, please. The dissent was written by Judge Overstreet and joined by Judges Thies and Judge Holder White. And while they previously, in their dissent, back when they first issued the opinion in February of this year, they focused on statutory interpretation. In this new dissent, they focused more on practical and constitutional concerns. There's some good nuggets of the dissent up here on the slide, but I'll just highlight some of them. They said the majority subverted the intent of the Illinois General Assembly. And that's interesting to note because in the case earlier decided this year, Timms versus Black Horse, which decided the statute of limitations for BIPA claims, as well as in this White Castle decision, the majority said that they were looking at the intent of the legislature. Now, the legislature's intent was very old. And as you know, technology, greatly changes over the years, even in just a year. So the legislative intent back, in 2008 when BIPA was enacted, some could argue that that's stale. But that's something that the Supreme Court looked at in issuing their decisions. And so the dissents used that and said that the majority actually subverted the intent of the legislature. They said that obviously the decision threatens the survival of businesses in Illinois. And it also raises significant due process concerns under the Constitution, which is something, that we have been arguing as a defense bar for a while. They noted also that under the majority's view, let me see, is this the next slide? Yeah, under the majority's view, the legislature obviously did not intend for Illinois businesses to be subject to cataclysmic job-killing damages. And instead, actually, it's interesting to note that BIPA noted the positive effects of biometric technology when it was enacted, but many can see that the effects are that people are very hesitant and businesses don't want to use biometric information in their technology and everything, their devices, because they could be subject to these class action lawsuits that continue to grow. And the dissent finally noted that All of this was done by the majority, despite the fact, and this is key that we argue a lot, that the plaintiff has not alleged a data breach or any costs or other damages associated with identity theft or compromised data. And that's the case in nearly every BIPA class action, dare I say, maybe all, that we see here in Illinois. Next slide, please. So that was a little summary of the White Castle decision. And of course, we want to talk about what that means. So after this decision, there was outcry by many organizations, including, the Illinois Chamber of Commerce, as well as a number of other business advocating organizations in Illinois. And those organizations have implored the legislature to act. Over the years, there have been those calls to act as well. And this year, nothing has happened in response. When I say nothing, I mean there has been no bill that's passed or amended BIPA. The most movement that the legislature made was earlier this year, and they proposed a bill that would increase the lowest statutory recovery from $1,000 to $1,500 per violation for negligent violations. Now, of course, that was awful and an awful proposal, from a business perspective. But in that bill, they did propose eliminating per scan accrual. So it would be, one accrual per person instead of, 4+ accruals per day per user. So now we're kind of looking at, again, what does this mean? So this law has not changed, and it's unlikely, just given the history of legislation, that there is going to be much change, though we can hope. Regardless, on rehearing, we were hopeful, but we didn't really have a lot of hope given the way the Illinois Supreme Court has ruled on the decisions over this years. And it really hasn't changed the playing field for the plaintiff's bar or the defense bar very greatly. And instead, now we're starting to litigate the class actions that have been stayed over the years waiting for these decisions. And we have many tools left in our toolbox. The first, of course, is a really solid policy and consent form. Now, we hope many of you on this webinar, you already have policies in place if you're using biometric technology or technology that could be seen as using biometric technology. However, the law continues to change, and plaintiffs are expanding their theories, and technology is evolving. So while these BIPA class actions initially targeted timekeeping devices, they are still being filed against companies and employers using those devices, but there are so many technologies that are being targeted as next. There's voice-activated headsets, driver cab cameras, try-on technology, online try-on technology, automated medication dispensing systems, security access devices are just a few that are being targeted now. So we would encourage you to reach out to your attorneys. Of course, feel free to reach out to us and review your policies and make sure that those policies still protect you in light of this evolving landscape. Other tools that we have in the toolbox, there's a lot of defenses that we're raising in litigation. Arbitration agreements are ones that are very helpful in eliminating obviously class actions, because often they include class action waivers and of course require that the individuals litigate in arbitration instead of in court. Unions' collective bargaining agreements provide a great defense. If you are a government contractor, we've had great success lately obtaining dismissal based on a government contractor exemption in the language of BIPA. Another tool we're using is that, I didn't mention it earlier, but the Illinois Supreme Court, even though their decision was, we disagree with it greatly, they did acknowledge a really strong defense that we've been arguing to the plaintiff's bar for years. And they've noted that under the language of the statute, damages are discretionary. So we are seeing and litigating some factual scenarios in order to try to diminish plaintiffs' damages claims. There are also a lot of factual deficiencies on a lot of the cases that are being filed. You may be surprised to hear that there are some plaintiffs' counsel that are not vetting their cases before they file them. And we're finding some success in, digging into the cases and raising some issues that maybe aren't true in order to get dismissals. There's class certification defenses that we've been making. And then there's many arguments that we've made early on in the motion to dismiss stage that while courts have found they are sufficiently pled early on at that stage, we're developing some of those defenses through discovery, and we'll use them to continue to attack BIPA claims. So now we're going to talk about some of the cases of note that we find interesting. These, of course, are not all of them, but we're in a short webinar, so we can go to the next slide, please. Wanted to give you an update on the BNSF case. So as many of us know, last year BNSF was found liable in the first ever BIPA jury trial. The class was awarded $228 million in damages, and that was calculated using the higher $5,000 per violation statutory damages amount under a willful or intentional violation standard. After that decision, the parties have, filed post-trial briefs and have engaged in that. And just recently, the Judge Kennelly, granted the defendant's motion for a new trial on damages. So that trial is scheduled for October 2nd. We're watching that closely. The parties actually just today filed motions in limine, and interestingly, BNSF filed a motion in limine to decertify the class if the plaintiffs try to introduce evidence that they actually were harmed. Now, under BIPA, there is no requiring of actual harm. That's another great decision by our Illinois Supreme Court saying that no actual harm is required. You can simply just recover statutory damages. And as we said earlier, of course, none of these plaintiffs have alleged that they had any data breached or were harmed by using biometric devices. And so BNSF is using that to say that if the plaintiffs try to introduce harm and show why they are entitled to discretionary damages, then that will require an individualized assessment. And that obviously is not proper for maintaining a class. The plaintiffs also filed a motion in limine arguing that the jury actually cannot award them anything less than the statutory amount. They claim that it's actual damages or the statutory amounts. And even though there is the word that a court may award these damages or a fact finder may award these damages, they're arguing that actually it should not be discretionary and they are at least entitled to the statutory amount of $1,000 or $5,000 per violation. So we're watching that closely. And again, you can probably expect to hear more from us after that trial. Next slide, please. Another big decision that we're watching and that's progressing is in the Mosby versus Ingalls Memorial Hospital case. That is a case that is up before the Illinois Supreme Court. And at issue is whether finger scan information collected by a healthcare provider from its employees falls within BIPA's exclusion for information collected, used, or stored for healthcare treatment, payment, or operations under HIPAA. Now, that language that is in quotes, that's part of an exemption in the BIPA statute. And so at issue is whether I should say, in this case that's up before the Illinois Supreme Court, and it involves the use of Pyxis automated medicine dispensing devices that were accessed using the healthcare worker's finger. There are many cases that involve that same technology, and those are stayed while we wait for the Illinois Supreme Court to issue their decision. But I do note there are also a number of class actions that are brought against healthcare providers that don't involve that timekeeping, that involve timekeeping and not that Pyxis technology. And because the Illinois Supreme Court's decision on this issue could give a broad answer that would cover healthcare providers that use other technology, there's a number of cases that are also stayed on that basis. This is, I think, a very interesting issue before the Illinois Supreme Court. There's a very strong argument that the legislative intent was to interpret BIPA so that they were consistent with HIPAA regulations. HIPAA regulations have encouraged healthcare workers to use biometric technology for years. And so the answer to this question will really turn on statutory interpretation. The appellate court, before it was appealed, held that the Pyxis technology or the Pyxis devices were not covered by this exemption. And so we will see how they rule. The interpretation really revolves around the placement of the word or, and whether the last portion of this exemption should apply only to patient information or any information used in the healthcare treatment under HIPAA. Oral argument in this case is scheduled for September 21st, so it's coming up. And I just want to note one more thing, that in the meantime, plaintiffs bar, they are not deterred by the Illinois Supreme Court's potential ruling that would eliminate class actions against healthcare providers. And still, they're actually continuing to file new suits and target new technology used by hospitals and healthcare providers that may fall under this exemption. And with that, Ada is next. She's going to talk about some other interesting decisions.
Thanks, Danielle. I feel like in prior webinars, we spent a lot of time talking about some of the preemption defenses that have stuck. And now we're starting to see the plaintiffs bar go after cases where there is a potential to lose where an exemption could apply, which it's telling in that it means they've sort of sued all of the low-hanging fruit at this point and are starting to take on more challenging cases. So we'll talk more about some other exemptions that are found in BIPA and that have been litigated recently. So Danielle was talking about the HIPAA exemption, which will be very impactful in terms of whatever that decision comes out to be. And we're going to move next and talk about the financial institution and affiliates exemption. So I'm going to use an example case that just came out recently. We'll talk about lessons learned from these cases and what you can do to put yourself in the best position to prevail if you're asserting this exemption. So first, the exemption that's at issue here is the exemption of nothing in this act shall be deemed to apply in any manner to a financial institution or an affiliate of a financial institution that is subject to Title V of the Graham-Leach-Bliley Act, which I will call the Graham Act as we go forward. So importantly, this language uses a very broad introduction, in any manner, and that is somewhat unique in the exemptions found in BIPA. Then it also has this provision that references an affiliate. So I'll talk about the litigation that surrounded the affiliate piece as well. The example case is a student filed a class action lawsuit alleging that the university's test proctoring software violated BIPA, and it's interesting. Many of these institutions that have been asserting the financial institution exemption have been universities and other education facilities that are providing student loans, or in this case, a kind of software interacting with students. So in all of these cases, the defense counsel typically moves to dismiss at the pleading stage. And some of these cases have been successful in pointing to information that the judge can take judicial notice of. So for example, in this case, the court was provided with and cited to the FTC definition of a financial institution in its regulations, which is quite broad. and the court found that sufficient to conclude that the exemption applied. What's key is that the motion to dismiss, this is technically speaking from some judges' perspective, a defense to the lawsuits. So you need to make sure that you are sticking with sort of the rules of what a judge may consider on the motion to dismiss pleading stage, and to the extent possible, locating materials that the judge will have no issue taking judicial notice of, and that is going to give you the highest likelihood of prevailing in that early stage. There's another case on the same topic where it sort of demonstrated that in terms of the defendants attempted to have the judge take judicial notice of some policies and materials that applied to the university. The judge found those sort of outside what she could consider at that early stage of the case, and also questioned whether the defendant had met its burden of meeting this concept, which is found in the Graham Act, that someone, to be a financial institution, you have to be significantly involved in those activities. So that's a lesson in terms of what to do in terms of motion to dismiss of really any exemption, is do as much as you can to locate materials that the judge can take judicial notice of or that the parties don't dispute. Next slide, please. Okay, so now we go to the next big thing, which I'm sure everyone is excited for, lawsuits that we're seeing now under the Genetic Information Privacy Act, and we have seen these pick up quite a bit, even over the last couple of weeks. What's interesting is this lawsuit is very similar to BIPA. It was enacted in 1998, so it calls into question whether BIPA, use this as a template in some ways. So the focus on GIPA is the use of genetic testing to determine suitability for insurance coverage or employment. There are other provisions in there, but that's the primary focus. So like BIPA, it contains no statute of limitations. It contains no specific definition of what constitutes a violation and whether you could have multiple violations for multiple questions, that sort of thing. Again, it's not resolved in this statute. A notable difference is that consent is not a defense or something that would provide a complete defense to the collection of genetic information. And that is distinctly different, obviously, than the BIPA cases. And it could impact as well some of the defenses that have been talked about and argued in terms of the union or collective bargaining agreement context. GIPA, unfortunately, has significantly higher minimum statutory damages than BIPA, so it's $2,500 per negligent violation and $15,000 for an intentional violation, or actual damages, whichever is greater. So again, language is very consistent with what we see in BIPA, and we've seen the courts rule, at least at the Illinois court level, that no harm is required in order to recover these statutory penalties. Next slide, please. So GIPA defines genetic information by pointing to HIPAA and a HIPAA regulation that's been promulgated. That regulation has a pretty broad definition of genetic information, and the piece that the plaintiff's bar has been seizing on is the individual's genetic tests, the genetic tests of family members, the manifestation of a disease or disorder in family members, or any request for receipt of genetic services or participation in clinical research. So it's a fairly broad discussion about what constitutes genetic information. And this part 3 here has been construed in the new lawsuits as family medical history. Essentially, the collection of that material plaintiffs are arguing is in violation of GIPA. Next slide, please. What we're seeing is the plaintiff's bar targeting primarily manufacturers, but any employer that conducts a pre-employment medical examination is at risk. And regardless of the actual facts, again, kind of harking back to the BIPA context, where often all that's known is the use of some technology, or in these cases, the use of a medical examination. And we're seeing cookie cutter complaints allege that they were asked for family medical history during a medical examination. These are often accompanied, so if you get these sort of requests for medical records about various employees, and that should be a red flag to you that there's someone considering a lawsuit involving GIPA. Make sure you take a look at that HIPAA release that's provided, which is specifically seeking medical information, because you still have obligations under HIPAA not to disclose more than is allowed. And with that, I'll turn it back to Danielle. And you're on mute, Danielle.
Thank you. That was the most important information probably everybody wants. The CLE code I just read is SS, as in Seyfarth, 4497. SS, Seyfarth, 4497. We also note there's a number of questions in the chat, and we're at time, but please feel free to reach out to us, or we'll try to reach out to answer some of those questions. Thank you, everyone, and thanks for joining us. We hope to see you next time.